Okay, well, welcome everybody. We're very pleased to have Judge Denny Chin as our speaker today. A court's view is basically this is going to be a frank and honest view of the judicial process, and I think it'll be we'll all benefit from it. Now, Denny fits into this category of he needs no introduction, but on my contract it says I have to do an introduction, so I'm going to do a short one. Denny was born in Hong Kong. 2 years later, he came to the United States with his folks and lived in Hell's Kitchen. He went to Princeton and graduated magna cum laude in 1975. 3 years later, he graduated from the Fordham Law School. He was the managing editor of the Fordham Law Review. And of those who know law reviews, a managing editor is the one who does all the work and is responsible for the successes. To some extent, the editor-in-chief is more of a, well, no, does work, but it's a managing editor who actually puts everything together. Clerked for Judge Worker in the Southern District. Private practice for a few years, went U.S. Attorney's Office, Southern District for 4, then was nominated by Bill Clinton to be a district court judge in the Southern District. And then later, 2010, I think you're nominated by Barack Obama for a position in the Second Circuit. More recently, Judge Chin has assumed senior status on the Second Circuit, which means you still hear cases and all, but you're not in the box, so to speak, of getting cases automatically, and you can pretty much control how much you want to do, and some do a lot, some do a little. We can talk about that if anyone's interested. He's also been involved in some big cases, Google Books, Fox v. Franken, future Al Franken committed trademark violations, supposedly in a theoretical book. Aereo case in which they created all these little antennas and everything else, and his panel bought it. Judge Chin said this is a scam. Ultimately, the Supreme Court agreed with him. Let's see what else. Bernie Madoff, the Ponzi scheme person, architect. Judge Chin sentenced him on 11 counts, consecutive sentences of 150 years, and really meant it. And that's what he I think recently just died in jail. Okay. Also, he has been an adjunct professor at Fordham a tremendously long time. And what I'm really impressed with, he was an adjunct professor of teaching legal writing, which has no prestige or anything else. But when I first came to Fordham, I was a full-time professor, and I taught legal writing for 7 years until they kicked me out. I think it's one of the most important courses in the curriculum, and especially these days, crucial for students. So I'm very impressed and hardworking. Adjunct, you can sort of redo the same thing year after year and another course. Every year with legal writing, it's new things, everything you have to read and everything else. So it's a tremendous amount of time. So well done. So recently he was appointed the Lawrence W. Pierce Distinguished Judge in Residence, and that's Judge Pierce was a Fordham graduate, I think recently died. And it's a great honor, and no one deserves it more than Judge Chin. Okay. A whole bunch of stuff outside of school that he's been involved in. words and positions. Okay. With that being said, if you want to ask a question, I think you have to go to the Q&A. We can't, even though I prefer to raise the hand to be able to see you, we can't see the audience in this webinar setup. So you have to click on Q&A and put in a question, and that's how we're going to be getting our questions from the audience. Okay, without further ado, it's all yours, Denny, and thanks so much for coming.
You're very welcome, and thank you very much, Professor Hansen. And it is really an honor for me to be giving this lecture, and also to have been named the Lawrence W. Pierce Distinguished Jurist in Residence. I am a great admirer of Judge Pierce. I met him when I was in law school, and like me, he was also a district judge, and then the circuit. And part of what I'll do today is talk a little bit about the differences between the trial court and the appellate court. I do have some slides. I'll go through my slides, talk for a bit, and then we'll, Professor Hansen's going to grill me for a bit, I suspect, and then we will turn to the audience questions. So I've now been hearing IP cases for some 27 years, about 16 years in the trial court, a little more than 10 years on the appellate court. And like most federal judges, I had virtually no IP experience before taking the bench. I had done a fair amount of labor and employment law. I had been in the U.S. Attorney's Office in the Civil Division. I had also been at a big firm and in my own firm. When I was at the labor and employment firm, one of my partners asked me to help out on a fabric ripoff case. This was my only foray into IP law before I became a judge. And someone alleged the infringement of a fabric design. And our first order of business was to go shopping. My partner and I went to the women's wear department at Century 21, and sadly, we quickly found some garments on the racks under our client's label with a pattern that was virtually identical to the plaintiff's pattern. And so we settled the case quickly. That was my introduction to IP law. But I came to enjoy the area very much. I found IP cases to be challenging, fun, often fast-moving, with motions for TROs and preliminary injunctions. There were good legal issues, often cutting-edge issues like in Google Books and Aereo. Because there was usually a lot at stake, a lot in terms of money, the lawyering was very good, and it was always a pleasure to have good lawyers in front of me. And often there were consumer products, such as hair products. And this was a trade dress and trademark case, Thermosilk versus Thermoshine. And yes, I issued an injunction and enjoined Thermoshine. Another rinse case was the Listerine case, Listerine versus Floss. Listerine was targeting lazy flossers. And it came out with this advertising program suggesting that you did not need to floss if you rinsed with Listerine, and this was a false advertising case. Johnson & Johnson, the leading manufacturer of floss, brought suit. And I spent a week listening to dentists and doctors testifying about plaque and gingivitis. I remember cross-examining, this was a bench trial, it was a hearing on the preliminary injunction, and I asked a few questions of Pfizer's doctor, and did he still floss? He said yes. Did he tell his patients to floss? And he said yes. And that was typical of some of the testimony that I was getting. And so ultimately I ruled in favor of the flossing companies and held that the advertisement was indeed false. And as you can see on the tag, the label, it's now clinically proven. And so Listerine had to prove that indeed rinsing was effective as floss. In terms of relief, by the way, what do you do about this? Do you pull all these bottles of Listerine from the shelves in the pharmacies and grocery stores? I thought that was too much, and I don't know if it was my idea or one of the lawyers. Instead, Pfizer was required to go into the stores and put a new sticker on top of the one you see there, the offending one. The new sticker did not make the claim that rinsing was effective as flossing. The one type of IP case that I did not care for was patent cases. This is another Pfizer case involving a dental rinse. This was a patent and trade dress case. The principal claims were the patent case. And I believe that this was my first patent case. It was relatively early on. And it was also one of my first trials. We went to trial on this case. And I had experienced patent lawyers on both sides. And I remember one argument where both lawyers said the law is absolutely clear. But the lawyer from one side said the law is X, and the lawyer for the other side said the law is Y. And of course, I had no idea. And this was the kind of thing that we had to deal with. Not only was the law hard, the law was new for me, but we also had to deal with, in this case, the chemistry. And a key issue was the use of tetrasodium pyrophosphate in the formula for plaques. Another patent case that went to trial was Scanner versus ICOS. And this case involved trigonometry. This slide and the next one are actual exhibits from the case. And the handwriting are the notes I made during the trial as the witnesses were explaining these things to me. And you see how complicated the formulas were that were used. This had to do with scanning these tiny ball bearings that were inside cell phones and other devices. They all had to be of the exact same height. Otherwise, you wouldn't have a good connection. How do you scan millions and millions of these things to make sure that they are of the same height efficiently, effectively? Well, it had to do with cameras, shadows, and trigonometry. In the plaques case, the one before this, there were so many claims. I think it was over 20 claims, 28 claims that the parties wanted to put to the jury. The jury was going to be given a special verdict form that asked them to answer questions on more than 20 claims. And my instant reaction was that there were too many claims. This was too difficult. It was going to take forever. And maybe it was because I wasn't used to patent cases, but my common sense said, some of these claims are going to depend on others. Some, you're not going to win some and then lose others. They were, most of them were going to fall or rise in the same way. And I persuaded the parties, both sides, to agree to submit a far fewer number of claims to the jury. And it worked out better. In the Scanner case, this case here, the one with the trigonometry, I tried hard to settle the case. and met with the parties, the clients, several times, and I failed to settle the case. But the parties, to my chagrin, wound up waiving jury, and I had to decide the case non-jury. Query whether juries should be deciding patent cases in the first place. But in any event, this was initially a jury case. A jury case is either asked to give a general verdict or is given special interrogatories, but it only needs to say yes or no to the different questions. If there's an award of damages, all it needs to do is pick an amount. It doesn't have to explain. On the other hand, after the parties waived, I had to make findings of fact. I had to explain my decision, and I had to write an opinion. And in some ways, it certainly added to the time it took. And these cases, I think, highlight some of the differences between the trial court and the appellate court. In the trial court, the judge plays a significant part in the shaping of the record. What evidence comes in, what evidence stays out, what claims are put to the jury, what will the verdict sheet look like? And by the way, many lawyers don't even focus on this until too late. They should be thinking about what the verdict sheet will look like even before the beginning of trial. What to instruct the jury, what to say and how. That's always a difficult area, and one where a court can get reversed. It's hard to get reversed on evidentiary issues, but it's not that hard to get reversed on an instructional question. And quite often you had to make these decisions right away. Off the top of your head, you have a jury sitting in the box and you've got a rule on the objection. You can't go back and think about it. And there is the overall issue of moving cases along, controlling your docket. There are much heavier dockets in the district court. You got to worry about the criminal cases with the speedy trial constraints. Some judges would put time limits on the presentation of the evidence at trial. For example, each side can have 10 hours for witness time. I actually tried it once and did not like it at all. You know, I felt I was more of a timekeeper than being a judge, and it was distracting. And so I didn't do it again after that one time. But I always set time limits on openings and closings. I had lawyers thanking me afterwards for giving them a time limit. It helped them focus. The juries can only listen for so long. I would otherwise try to move the lawyers along, ask for an estimate at the beginning, et cetera. Ironically, in the patent cases, you know, very few trial judges have patent experience, and yet the appeals went to the experts in the federal circuit. I'm pretty sure that I got reversed half the time in my patent cases. So thankfully now in the Second Circuit, for the most part, we do not get patent cases. Occasionally there's a patent issue. There is much less pressure in general in the appellate court. We have fewer cases. We have time to ponder, more time to write. There are three of us. It's helpful to have three of us, although sometimes, of course, it's a pain in the neck. I miss the days when I could make my own decision. And sometimes we don't even have to explain our reasoning. I'm surprised at how often in the appellate court we wind up ducking hard issues. Someone once said that the difference between the trial court and the appellate court is the difference between the search for truth and the search for error. And in my view, it's a lot more fun searching for truth than it is searching for error. I have always enjoyed the copyright cases. You know, we would get to watch movies or read books or play with toys. And this was from an early case. I still have these gorillas in my chambers. Is the idea of a stuffed gorilla copyrightable? The concept, the idea, no. The expression of the gorillas, yes. And here, in my view, the two expressions were too close. And so I enjoined the sale of the copy. And if you're wondering, you can see the small red K on the hang tag for this one, and that was Kmart. This was a Kmart special, and it sold for $19.99. The original sold for a lot more. Over the years, I had a lot of music cases. Most of them were copyright cases. The late great Whitney Houston was sued for allegedly infringing the phrase "clap your hands." Of course, such a common phrase is not copyrightable, and I dismissed that case pretty quickly. Mariah Carey was sued not once, but twice. One plaintiff claimed she stole the music to the song Hero, and another plaintiff claimed that she stole the lyrics, the words to the song Hero. Now, unfortunately, I never got to meet Mariah Carey. She never came to court, but her lawyers brought along a recording. And what a lot of these artists do to protect themselves from these copyright cases is to record themselves as they are working. And I could hear Mariah Carey and her partner at a piano, trying out different tunes, trying out different words. The words and music, you could tell were the early versions of the song Hero, which went on to be a huge hit. But the recording had the ring of truth to it. You could see two artists working hard to come up with a hit song. The plaintiff, who was a bodyguard for Sly of Sly and the Family Stone, who were big when I was in college. His story was that one day he sat down and in 5 minutes wrote a poem that was perfectly word for word the lyrics for the song Hero. And that did not make sense. You know, things do not come to you so easily. And of course, we've had a lot of music cases. Again, most of them are copyright cases. The Donnie Brasco movie actually was not a copyright case. It was a libel case. The movie was based on a book written by Donnie Brasco. It was a true story. Donnie Brasco was an FBI agent who went deep undercover with the mob for like 5 years. And then he came out and wound up testifying against many organized crime members, got many convictions, and Johnny Depp played Donnie Brasco. Al Pacino played the head of the family. Well, one guy is depicted in the movie as participating in chopping up a body. And he was offended because he did not participate in the chopping up of a body, and he sued the movie company and the producers, et cetera, for libel, saying that he had been libeled by being depicted as participating in chopping up a body. The defendants argue the libel-proof defense. They argue that the plaintiff was libel-proof. And it is what it sounds like. The argument was that the plaintiff's reputation was already so bad he could not be further damaged. He was libel-proof. And I was persuaded. He had a horrible record. He had been convicted of a number of things: racketeering, drug dealing. He was under an indictment when he brought the case with other federal charges. And so what was claiming that he had participated in chopping up of a body was a big deal. During the presidential campaign, 2 campaigns ago, my case was actually cited by the Wall Street Journal and others. If you recall, then candidate Trump was, the the subject of an article in the New York Times, reporting that several women claimed that he had sexually harassed them. His lawyer wrote a letter to the Times threatening to sue. The Times responded by citing my case and the libel-proof doctrine. And I will leave it at that. A fun movie was Groundhog Day, and it comes out every Groundhog Day. It's shown on TV, and the Bill Murray character tries to make the Andy McDowell character fall in love with him. But it's based on the concept, the idea of a man trapped in a repeating day. The man remembers what happened as he lives the same day over and over again. Everybody else starts from scratch. Well, there had been a novel called One Fine Day based on the same idea, a man trapped in a repeating day. Again, the storyline, the idea of a man trapped in a repeating day, it's not copyrightable. But the expression of that idea could be copyrightable, is copyrightable. But here, I thought that the two expressions were very different. Groundhog Day was a romantic comedy. It was a vehicle for Bill Murray. He took a piano lesson every day, learned to play jazz piano. He saved a kid falling out of a tree every day. He learned to sculpt ice and made a beautiful ice sculpture of Andy McDowell, etc. The novel was dark and depressing, and some of the repeating events were a plane crashing every day, 150 people dying every day. And so I dismissed the complaint. Another movie case, and I wound up using, this is the first page of my opinion on the left. I used the movie poster in my opinion. And one of the fun things about these copyright cases was I was often able to insert images into my opinion, which made it more fun. This was a case I had in the circuit about a year and a half ago. And it is an example of why I enjoy the copyright cases. We had a lot of fun writing the opinion. This was a reboot of the Star Trek story on the CBS streaming channel. It featured something called a tardigrade. And a tardigrade is a real life microscopic animal. And research shows that it can survive in extreme temperatures, really cold temperatures, really hot temperatures, and it can even survive in outer space. And it's a tiny thing, a couple of millimeters long, but in Star Trek Discovery, they had 3 episodes where they had a large tardigrade traveling in space and devouring people. Someone had come out with a video game sometime earlier featuring a tardigrade traveling in space. And so Mr. Abden sued for copyright infringement. And we wound up, the complaint was dismissed. We affirmed. And we worked in some iconic lines from Star Trek into our opinion. I don't usually incorporate pop culture into opinions, but I thought that this was the perfect case for doing that. And we have, for example, the line, "Where no court has gone before, the needs of the many outweigh the needs of the few or the one." You remember the scene where Spock is dying. We found a place to insert that line. And of course, live long and prosper. And in fact, it was one of the other judges on the panel in reviewing the draft of the opinion that suggested, and she suggested a great spot to use that line. And so we did. Facts and ideas are not copyrightable. There have been experiments, for example, where tardigrades were sent into space. And there are many familiar concepts, scenes à faire, stock themes, generic themes. You know, and of course, we were looking at movies and books featuring space and space travel. We looked at the total concept and feel of the two works. We looked at what was protectable and what was not protectable, and what was left after you extracted the unprotectable elements, and we affirmed. Let me now focus on two cases, cases that Professor Hansen mentioned earlier in his introduction. They were decided some years ago, but I think they are useful to help illustrate, you know, how judges think, how judges decide cases. And so Google Books and Aereo. So first, Google Books. The Google Books website is well known to all of you, although I checked this morning and it looks different, very different from the way it looked when the case was decided. But I think the concepts are the same. And Google has scanned millions and millions of books over the years, many without permission, many still under copyright. And they've digitized the books and made them searchable and created an overall index for all the scanned books. One of the named plaintiffs was Jim Bouton, the former pitcher on the Yankees, who wrote Ball 4. So Google Books no longer looks like this. These were, you know, exhibits from the time of the case, and this was done without Mr. Bouton's permission. And some of the points, and the principal issue, of course, was fair use, the fair use defense. And some of the things that appealed to me, that made sense to me, were that there were no ads. Google was not trying to compete. It had links to booksellers. And so by doing the search, if you became interested in Ball 4, you could buy it from Barnes & Noble, you know, or Amazon. Google was not trying to sell books and make a profit in this way itself. Google Books displayed snippets. These are what the snippets looked like back then. When I looked this morning, you could see that the snippets have gotten bigger. But back then, they were maybe, you know, an eighth of a page. Each search generated a few snippets. You could vary your search slightly and get more snippets. But Google took security measures to make sure that you could not get the entire book. Even if you wanted to sit there and try to come up with enough snippets to get the entire book and then cut and paste them, and, you know, instead of spending $30, it was impossible because certain pages were blacked out and you couldn't get everything. And that was important to me because, again, Google was not trying to compete. If you're wondering who Steve Hovley is, this is Steve Hovley. He spent 8 years in the majors with a batting average of .258. So I granted summary judgment to Google and held that it prevailed, the fair use defense prevailed. And of course, with everything, we should start with the words of the statute. And what did the words say? The fair use of a copyrighted work for purposes such as, my thing is covering up here, is not an infringement of copyright. And of course, over the years, there have been case law with, in particular, my colleague Judge Laval's article on fair use in the Supreme Court's decision adopting it. And you looked at a number of factors. And in my decision awarding summary judgment, I went through the factors. And this was a transformative use. It was taking the words expressive text of books and transforming them into a comprehensive word index. librarians, researchers were using it. I know law review editors depended heavily on Google Books as a site checking tool. And so Google Books was using words for a different purpose. I remember one of the examples given was data mining, text mining, going back and looking at how often words were used in one context. I remember the example they gave was United States is or United States are. And earlier on, are was used, and then over time, it became singular to is. And so that was a use of Google Books, of text and search that added some value. There was no intent to supplant or supersede books. And there was a means of creating benefits to the public, preserving books. You know, you always look at the purpose of a law. And here, I thought this struck the right balance between protecting the rights of authors and inventors while encouraging creativity, allowing others to use protected works to advance the arts and sciences. It improved accessibility. I remember in an earlier phase of the case, the settlement phase, I wound up rejecting the settlement of the class action, but there were 2 busloads of blind people who came to sit in on a hearing because Google Books was very important to them. The digitizing of books was very important to them. This is Judge LaValle's original law review article and the Campbell case that relied heavily on it. And let me switch to Aereo. You know, the subject of technology, you see the tiny antenna there, the size of a dime. Aereo was capturing over-the-air broadcasts of copyrighted shows. I mean, for example, the Super Bowl, without permission, again, without permission. And then permitting its customers to access the programs by streaming them to their devices for $9.99 a month. This was one of the early streaming programs. And Aereo elected to use these tiny antennas so that each customer was assigned his or her own antenna. And the argument was because each customer got a private antenna, this was a private transmission, not a public transmission, and therefore not covered. And again, we start with the words of the statute. The owner of a copyrighted work has the exclusive right to transmit or otherwise communicate a performance to the public by means of any device or process. And the question was whether this was a public or private performance. And Aereo, like the trial court and the majority, relied on the Cablevision case, or otherwise known as the Cartoon Network, and held that there was no infringement because Aereo's use of the private antennas made this a private transmission. I dissented. First of all, I thought that Cablevision was wrongly decided. And I should disclose, of course, that I was the trial judge in Cablevision. I had come out the other way. The Second Circuit reversed me. But in any event, I knew that in Aereo, whether I liked it or not, we were bound by the Cablevision case, by Cartoon Network. But I thought that Cablevision was distinguishable, that Aereo was distinguishable from Cablevision, and that Aereo and the majority were pushing Cablevision beyond where it should have gone. And I called for an en banc vote. It was 2-1 against me. I dissented. It is only one of 2 times in my time on the Second Circuit that I called for an en banc. And if we went en banc, we would have had the ability to reverse Cartoon Network as an en banc court, what the panel could not have done. But I was voted down. I dissented from the denial of en banc, and only one other judge joined me in the dissent. And as you heard, the Supreme Court took the case and went my way. This was some years ago, and most judges back then and still today, are not adept at technology when it comes to technology and social media. This is a fax machine. In the Second Circuit, we were still using the fax machine until the pandemic. I'm pleased to say that the pandemic has killed the fax machine in the Second Circuit, and the pandemic is forcing many of us to adapt more to technology, as we've had to work largely remotely. And of course, technology is constantly changing. And one of the challenges is that we, the courts, have had to apply longstanding principles, statutes written many years ago to this new technology. At oral argument in the Supreme Court, the lawyers were using analogies to things like parking lots and handing your car keys to the parking lot attendant. And Justice Breyer asked a question about phonographs. And I'm sure there were a lot of people who were not familiar with phonographs and LPs. So in any event, I was pleased to be vindicated. I had been hoping for double vindication. I was hoping that the court would also overrule Cablevision in the process. It did not. It stayed away from it, but nonetheless, I was more than satisfied. And so again, these cases show the importance of the words of the statute. The words are always a starting point, but you do have to look at the purpose of the law. You have to have respect for precedent, but we also have to think ahead about what may come. And I will turn it back to Professor Hanson. Thank you.
Just a minute. Okay, thank you very much. It's very interesting. And all right, so we have some questions in the Q&A, and so in terms of the overall approach of the Second Circuit, when I clerked, the judge would hear the panel, and I don't know whether it was 20, 25 cases. I don't know how many it was, but an opinion was written in every single case. Now in the Second Circuit, if let's say it is 25 for opinions might be written in 5, 6, 7 cases, and there's an order by the presiding judge or something, just sort of going through it and giving a result. Wasn't that shortchanged what we're trying to get out of judges? I mean, reasons for doing things, and how did that happen?
Yeah, well, first of all, it's probably fewer than 7 or 8 opinions out of 25 cases. It's probably 3 or 4 opinions out of 25. Okay. And then the others are decided by summary order. And this developed over the years largely because of the volume. As the volume increased over the years, the court started resorting more to summary orders. I remember when I was a law clerk, you would occasionally get a summary order. The summary order would be 1 sentence, 2 sentences, affirmed substantially for the reasons set forth by the district court below. Now we have 5-page, 10-page summary orders that do go into discussions of the facts and the issues, but they are not supposed to be cited. I think, many cases are easy cases, and we would not be adding much by writing an opinion where there isn't a lot in issue and there isn't any disagreement. And so we are trying to pick and choose cases where we haven't yet spoken, or there's something significant, hard, where we think the public would benefit from, more detailed explanation. I understand that some parties and lawyers feel frustrated when they get a summary order the next day that's 4 pages long that affirms. And not everyone on the court agrees that this is the right way to do it, or, but again, that's been the practice in recent years. As if the volume comes down, things could change. Another area, sometimes, and I kind of alluded to this about ducking, you might have disagreement among the 3 judges. And so one question is, should we write an opinion and then the one judge who's in the minority dissent? That judge has to say, do I want a precedential opinion that comes out the way I don't want? Or should I compromise, agree to affirm or reverse by summary order, which is non-precedential, and so that sometimes impacts the analysis. It is a way of getting agreement. You may get everyone to agree if it's a summary order, whereas if it's going to be an opinion, someone would stick to her guns and dissent.
Well, in that situation, the public's denied, the parties are denied. There was a real difference of opinion, which could be valuable as to what you're going to do in the next case, and then deprived of that. So, I mean, in terms of educating the bar as to really what happened, isn't it pretty important that they know really what happened rather than you guys get out of doing some work, or what?
Well, it's not in those situations. It's not to get out of work. It's a way to resolve a case expeditiously. If someone dissents, it's going to take months and months and months, and it's a judgment call that one of us has to make. Do I want to push it and have a precedent that comes out the way I don't want, as opposed to, sorry, my phone is ringing here. So it happens. Most of the time, it's because we've already spoken on an issue. There is ample Second Circuit precedent, and we don't see the need to write further on the issue.
Okay. All right. Different circuits. I'm a lawyer now, and I think one of the things lawyers should do more of is choose where to bring the case as opposed to bring it in the city in which they have their office, because you do see differences in the cultures and all of the approaches to, for instance, LA and New York as opposed to some court in Montana or something else, where the small guy might get more of a break because of that feeling of the world is against us, or whatever happens. So do you see, when you're seeing precedents in not foreign, but other circuits, when you haven't reached that issue, do you sort of say, well, that's all right, that's LA, and yeah, that's sort of like us? How do you deal with conflicting precedents from different circuits and going about deciding your case?
Well, it's always helpful, if we haven't decided an issue, to look at what the other circuits have done, even though their decisions are not binding. I mean, if a better reasoned decision will be more persuasive. Also, if every circuit that has addressed the issue has come out the same way, that would be reason for us to come out the same way, unless we think that 6 other circuits have gotten it wrong. We will, in that instance, by the way, sometimes issue a per curiam, not a summary order, but a per curiam, which would be, usually it's under 10 pages, saying 6 circuits have gone the same way, we come out the same way. There, we don't feel a need to repeat all the analysis and reasoning because it's been well done somewhere else. and we can just adopt that reasoning. But yeah, we won't ignore it just because it's from another circuit. We will, give it serious consideration.
Okay, let me take we'll be bouncing back and forth. Let me take, all right, so we have Judge Chin. Thank you for being here. What do you think about multi-factor balancing tests? For example, the Polaroid test for measuring likelihood of confusion came out in 1961. Do the Polaroid factors still work today?
Well, I haven't applied them in quite a while. I don't recall ever having a problem. I did apply them quite a bit over the years. Those kinds of cases we would get. I never felt a problem. It makes sense to look at a number of factors. It's convenient to have factors identified. You can always look at something else if a case presents an unnamed factor that might have an impact. And those factor tests, those multi-factor tests, I think are useful because nothing is exclusive. It gives you, it helps you organize your thinking. I mean, the fair use factors in Google Books, it's useful to be able to go through them. And again, there's usually, an ability just to, like a catch-all thing, to try and look at the overall picture and see if the result makes sense. So, I don't know what the current criticisms are, but I certainly had no problems applying the test over the years, and in fact found it useful.
Well, in a likelihood of confusion case, you get that case and you see what the two marks are. Most people, because we're all consumers now, get an immediate impression. In fact, that's what happens in surveys. They're not given time or anything else. They're supposed to say whether they think it's likelihood of confusion. I think judges are the same way. So do you find yourself, especially when you're in a district court, getting to a result in a likelihood of confusion case fairly early because of your own views of it, as opposed to, well, I won't think anything until I go through the Polaroid tests?
Oh, I think the natural reaction is to have an immediate reaction. You have an immediate reaction. I remember, well, you mentioned the Al Franken case, the title of the book, and I remember reading a news article about the case, and I had an immediate reaction. And then the case was given to me when I was the Part 1 judge. It was another judge had the case, but I was covering in Part 1. So I had an immediate reaction, which is natural. The case wasn't even mine then, but then I was careful to certainly, read the briefs, listen to the parties' presentations. And one thing I've learned over the years as a judge is, you have to be open-minded and wait until everyone has had a chance to be heard. If at a trial, you have highs and lows. Day one will go great for the government, and suddenly day two, things don't go so well for the government, and the defense will be scoring a number of points. And I always tell jurors to keep an open mind. So it's understandable, it's natural to have an immediate reaction, but one should be careful to keep an open mind, notwithstanding the initial reaction, and to take a good hard look at all of the evidence as it is presented.
Okay. All right. Transformative use. A judicially invented action that has no support in the copyright law. Why is this? Again, no basis in copyright law, the same person. What is the justification for this invention? It opens the door to vast abuses of unauthorized derivative use. Well, of course, the whole issue with transformative use, it started with your colleague in the Second Circuit and his article, and then the two views of it is people just went berserk, some judges, and it took over and it ignored the derivative work right. And then it seems that, if you agree, transformative use is being patted down a little bit and not is used to reach results that are perhaps not proper or whatever. In other words, it's less of a tool to do whatever you want in a particular case. Anyway, this person is saying it has no support in copyright law. Of course, everything that almost all of our law is judicially created, even when there's a statute, at least that's my opinion. But so what do you have to think of transformative use?
Well, I mean, I don't know that I agree that there's nothing in the statute. You know, you talk about advancing the progress of the arts and sciences, and I think it makes sense that it is a way to balance, you know, the rights of owners and authors against the ability of newcomers to make use of the copyrighted work to do better, to do more things, to do new things. And I think that concept is built in, and Judge Libel, when he wrote his article, was trying to, you know, make it concrete.
Well, Judge Libel had just been overruled in 2 cases, and I think he was almost bitter. And I maybe been in which I agree with him that he shouldn't have been overruled. But the framers of the law have a derivative use. Derivative use is exactly what transformative use is. So you have to ignore the written context that was put in by Congress and say, now I'm going to do this balancing because I like it better. Is that what you're saying?
Well, I mean, look, I think they're different things, and I think anything can be abused, and if there have been judges who have gone crazy by overdoing the fair use doctrine, that's unfortunate. But hopefully, the appellate courts will rein them in.
Okay.
But I think there's room for fair use, and that it's an important doctrine.
Oh, no, room for fair use, absolutely. You can see I don't have any views myself on these issues. I'm just being the neutral arbitrator.
I mean, judges sometimes get it wrong. Judges, unfortunately, some judges have agendas, and that's unfortunate. But you know,
Okay.
we do the best we can.
Oh, yeah. Question, what is the value of survey evidence?
It's been a long time since I had a case with survey evidence. I do remember having it, and I remember it being useful, but a bad survey can be cross-examined. I remember there being some effect. I can't remember which cases it was. But you know, a good survey can be criticized and cross-examined in essence, and you want to know what people out there think. It's helpful to hear evidence of more than just what one random stranger thinks, and to the extent that you can sample a larger group of people. I think that's useful.
Okay. Do you think the Supreme Court's decision in Aereo can be seen as tacitly overruling Cablevision?
I wish. I don't know. I mean, it was interesting that the court completely ignored it, given that the majority and the trial court essentially exclusively relied on Cablevision. I guess if you look at it that way, maybe yes. Who knows what they were thinking, but if the panel decision is relying exclusively on Cablevision and the court reverses, even though it doesn't overrule explicitly Cablevision, I think a good argument could be made that yes. There was also a lot of criticism, academic criticism of Cablevision. And so, yeah, maybe.
Okay, that's a good question. And to what extent do you think again, when I was clerking before you were born, I think, but the judge would, when I was in clerking in Second Circuit, said, go on and see what the professors think about this. I don't sense that professors have much clout today. If you just look at the in-bank decisions and what has happened with sometimes. What is your view on the role of professors in the law today? Well,
I think I largely agree that many of my colleagues don't pay much attention. I remember one of my colleagues on the Second Circuit saying that law review articles were, irrelevant these days. I think that's going too far. I did rely on what professors thought in Aereo. I had a section in my dissent arguing that Cablevision was wrongly decided, and see what the academics say. And it got me nowhere. I only had one colleague join my dissent. And by the way, before you get to the opinions, dissenting from the denial of cert, there are memos back and forth. And I had tried internally to persuade my colleagues to go along with me on some of these things with little success. The other area that's interesting, I think, is in recent years, we've seen a lot of law professor amicus briefs, green briefs, including in copyright cases, submitted by, a cadre of professors, specialists in the area, not just in copyright law, but in other areas as well. And I think, I find the amicus briefs helpful. We always read them. And that's another area where I think professors can have an impact.
So you are in a minority view then among judges about the value of amicus briefs from professors?
Well, I don't know. I don't know what others think. I get the sense that there are many colleagues who don't give much weight to what the academics think.
Okay, I'm bouncing around a little bit here. Do you think the Supreme Court's expansive decision, one is I don't think it was expansive, in Google v. Orgo, shows it's on a different page from the Second Circuit as fair use as shown in Warhol v. Goldsmith?
I don't know. I don't think I would opine. I'd leave it up to you on that. I mean, I don't know the cases well enough.
Well, the interesting thing is, Breyer wrote that. He also wrote, I forget the name of the patent case, of which very important case, but written away is this is not even a precedent of anything. This is all the same. We're not overruling this or this. And the reality is then people then take it and do what they want with it. So if the people who wanted Oracle or Google to really win see that case in a certain way, the people have seen it in another way. So the question is going to be what are courts going to do with this? And I think my guess is Oracle v. Google was a case for a certain crowd and industry, which was relying on certain things. You go outside of that, and it looks like it's not a very good opinion. So I think it'd be very interesting to see what happens in the future with that case. But you can't from the words, because Breyer wrote both of them very narrowly. That doesn't, however, mean that the people down the road will be as narrow or whatever. But
I think it's risky to try to guess what's going to happen in the future, because most judges try to write narrowly. As I said before, you do have to think about the future, what's to come. But usually we don't know what's to come. We don't know what's going to happen in the future, and we want to be careful that we don't lock ourselves in or box ourselves in when a different set of circumstances is presented. And so, until you have the actual issue, until you heard from the parties and the lawyers, we don't know what's going to happen. Who knows if Justice Breyer will be here, and so it is risky to try and guess what's going to happen in the future. And different sides will argue their points of view and try to say what you meant was this, and then the court will decide.
Okay. Just one more on amicus. I'm trying to make sure. Do the number of amici make a difference to you? For example, it's a growing tendency to list a number of academics on the cover of it. So is volume of amici have an effect on you or judges?
I would say not much effect. I mean, just because, first of all, if you have, I'm not sure that you're going to get the same things over and over again if you have, a dozen green briefs. And at some point, it's just too much to absorb. If I have a dozen green briefs, frankly, I'm probably not going to read them all myself. I might have an intern go through and read them and summarize them and maybe pick out a few that it makes sense. I mean, it's different in the Supreme Court because they have fewer cases. With us, when I will have usually it's going to be 4 or 5 days of sittings at one time in a row, that is. And so and every month, and I'm preparing for 25 cases. And if I have a case with really long briefs, multiple parties, and 11 green briefs, I'm not likely to have time to read all of it and be ready for all of my other cases as well. It can be, some are very impactful. In one of the affirmative action cases, the military's brief talking about the importance of affirmative action or diversity. We don't say affirmative action anymore. The importance of diversity in the military. I think that was a powerful amicus brief. So depending on who it is, what they are saying, the quality of the reasoning, they can certainly be important and influential. But the mere fact that there are 11 green briefs on one side and none on the other.
No, so I think the question was, how many people signed on to the brief? Like 45, 105? Does that make a difference to two?
I don't think so. I don't think so.
Okay. This comes in, Professor Hansen is a big proponent of legal realism. For judges for whom that is true, how do you think parties can best speak to the equities when a case reaches the appellate stage?
Well, I think look, I think it's important what the story is, what was happening. I remember one of the first times I sat with 2 other judges. One of them turned to me and said, "You were a trial judge. What was really going on here?" And I think the equities are important. Look, you can't let the equities affect your interpretation of the law. The law is what it is, but in many areas there is some discretion. There is some room. And certainly the stories are important there. The equities are important in those cases. And I want to know, I want to know what was really going on. So I agree with Professor Hansen on this.
Okay. Is it reasonable, we need to discuss this a little bit. Is it reasonable to expect juries to understand complex patent issues? Would jury trials for complex IP matters ever be abolished?
I don't know. I mean, I don't know that I've done enough of them. As I was suggesting earlier, I've done it both ways, and it can make sense. The average juror probably is not going to understand trigonometry. But, part of our system is you have 8 jurors from all walks of life, and they put their heads together, and maybe one among them will understand it well and help explain it to the others. One area where I think it is hard for judges is money, awarding damages. I think it's better to have 8 jurors from all walks of life putting their heads together and deciding what a broken leg is worth, what the death of a life is worth, as opposed to a federal judge who has led arguably a different kind of an existence, making that number. Although in IP cases, the damages usually aren't that kind of damage. They're usually more formulaic and you can figure them out, or you have an expert do the math. That first case I tried, the Plaques case, and then I wound up having to decide the equitable part of it. There were claims for an injunction. It might have been more efficient for the whole thing to have been a jury trial. I mean, a non-jury trial. I could have done everything at the same time. But I don't know. I think I would not try to opine on this because I don't, I think this is one where I'd want to know what the perspective is of the practitioners and the clients. Do they think it's worth the additional time and expense of trying it to a jury? One of the challenges is that the lawyers have to explain it to me and teach me, and then I have to teach it to the jury with the help of the lawyers. I mean, or I would assist the lawyers in teaching it to the jury. The jury charge is hard. There are different challenges. And as I said earlier, it's the jury doesn't have to explain. And it also may mean you get less justice on appeal because we don't know what the jury was thinking and the appellate court is left speculating. Whereas if it's non-jury and the trial judge has to explain the reasoning, the appellate court is in a better situation, a better place in terms of understanding.
Is there a difference on appeal to a jury finding a fact as opposed to the judge finding a fact?
There should be deference to both, theoretically. I think.
Well, there's a constitutional right to a jury. And if should that have some impact of what you do with a jury fact finding, for instance? I mean, one of the reasons you have that in there is they were afraid Federalist judges were going to take over and just run everything through facts and everything else. So the Seventh Amendment was supposed to be a check on judges just putting their own views in this thing, and therefore you're supposed to defer to these people. Now, as a practical matter, do you think in a case they're less likely to fool around with a jury finding a fact than in a judge finding a fact?
I think that's probably true. I think
Okay.
that's probably true, in part because, the judge will likely explain herself, and if the reasoning doesn't make sense, then we
Okay.
can see it to some extent. But I think, once a party has waived, I think theoretically, probably you should give just as much deference to the trial judge's credibility finding as you would to a jury. But I think realistically, it's probably easier to give deference to a jury. And then in the back of your mind, you're also thinking it's 8 jurors or 12 jurors, not just one judge, so that could be part of it as well.
Okay, final question. Years ago, the Second Circuit judges circulated voting memos to the other judges on a panel setting forth the tentative views of the case. Are voting memos circulated today, even in a small number of cases? Do you personally send out voting memos?
Yeah, it's an interesting question. Many years ago, when there were fewer judges on the court and fewer cases, the judges would hear argument and not even conference. They would circulate their voting memos supposedly at the same time. You weren't supposed to look at another judge's memo until you sent out yours. After the 3 memos were circulated, then the judges would conference, having had a chance to review the voting memos. But so there was a voting memo for every case. That is no longer the case. That fell by the wayside. Now, immediately after the argument, we have a conference. We have the voting conference then. And we have not exchanged memos. We haven't exchanged views. We don't know what the other judges are thinking unless you glean something from the questioning during oral argument. In many of the cases, the presider comes with summary orders. Let's say there are 5 cases on that day. The presider thinks 3 of them should be decided by summary order. The presider might have 3 summary orders written. And depending on what happens, the presider is likely to give out the summary orders. If indeed, usually the judges will vote, and if the vote comes out the right way, the presider will give out the summary orders. There may be some hard cases where the presider hasn't done a summary order. There may be disagreement. In those cases, you may have voting memos. There are some judges who don't want to do voting memos because it takes a long time, and and some judges want to just get to it. Let's figure out who's writing. Let the author write, and then we can deal with it. Some judges prefer to get it resolved through voting memos. So in part, it depends on who the panel is. And there are some judges who write long voting memos. They can be 20 pages long, single spaced. And they're circulated. And then another judge might respond, and that still is part of the process, this back and forth, but not in many cases.
As a practical matter, does the presiding judge have more clout as to the result of what that 3-panel will do?
Not necessarily.
Presiding judge, by the way, to everyone else, is just the most senior judge among the 3. Okay.
The most senior active judge.
Yeah,
the most senior active judge. So if you have 2 actives and a senior judge, the more senior of the 2 active judges would preside. The senior judge would not. I don't think a presider has more clout. It's going to be, you could perhaps in a particular case. You could try, but in my experience, it's been fair and open. It's going to be the 2 judges in the majority will dictate what the decision is. There may be some of this back and forth that I alluded to earlier, and maybe some compromise. There, that was one of my the things I had to get used to when I got to the circuit was compromise, because in the district court you're on your own and you don't compromise. But that's generally the process. And sometimes people will change their mind. Sometimes people are unsure, but we will take an initial vote right at the conference, right then and there. Affirm, 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 reverse, affirm, affirm, put me down as a question mark. I'm not sure, and when you have question marks, you're more likely to see a voting memo. Okay.
The final question, who has the best background in this? Is it you or me?
I think I win that one.
No, but you see what this means. I'm a man of the people, and you're in the upper stratosphere, and should be deferred to.
I could easily make myself a man of the people by changing my background, as it is virtual. This is what the judges see, but it's pretty, and it makes a good background for these kinds of presentations.
Okay, well, the time is up. Thank you so much, Denny. I really, really appreciated it. And thank you, everyone, for attending. I wish I could see you. And everyone stay safe. And thank you all. All righty. Bye-bye.
Thank you.